Tennessee is now in session. God save the United States, the state of Tennessee, and this honorable court. Please be seated.
Good morning, everyone. We're glad to see you on this beautiful day. We'll hear the cases in the order in which they appear on the docket. However, after the second case, we will take a brief recess. I'll remind you that we are live streaming, so whatever you say goes out in whatever the internet is and goes everywhere all at once. So remember, once said, it can't be taken back. And I say that not only to remind you, but to remind me too. If there's no preliminary matters, well, let's call the first case.
Dallas K. Hurley Jr. versus Ryan B. Pickens et al.
Good morning. May it please the court. I'm Scott Hurley, a member of the Knox County Bar. I'm here on behalf of the appellant today, and I would like to reserve, with the permission of this court, 5 of my 15 minutes for rebuttal if needed.
5 minutes, all right.
Thank you very much. It's a pleasure to be back before this court. This is a healthcare liability case that originates here in Knox County, Tennessee. It relates to a surgical procedure that was performed on January the 14th, 2014. A follow-up procedure to address massive complications that occurred on January the 18th of 2014. This case has been previously to this court on an appeal. There was an appeal as to whether or not the plaintiffs had the right to take a voluntary non-suit without prejudice. That matter came before this court and was decided, and ultimately went back to the trial court, and subsequently, shortly before trial, a motion was filed by the defendants asserting that the expert identified by the plaintiffs, Dr. Shannon Orr from the state of Mississippi, lacked sufficient qualifications to be qualified as an expert in the state of Tennessee. This case involves the application of and interpretation of Tennessee Code Annotated Section 2926.115b. That statute primarily addresses the requirements that an expert witness must have on a minimum basis here in the state of Tennessee in order to be able to testify and be qualified as an expert witness. There are 3 elements to that test. We're here, we believe, only about one of them. The first element is that the physician that purports to be testifying as an expert must be licensed. As such, there is no dispute in this case that Dr. Orr was licensed. The third prong or element of that test is a requirement that he or she be licensed in a state that is contiguous to the state of Tennessee, and that he be practicing in his profession within the year in which the alleged negligence occurred. We do not believe that there is any dispute really that was at issue here. What is at issue is a determination by the trial court that this expert lacked the sufficient qualifications based on his experience, his education, his training, and his qualifications as of the January 2014 timeframe, so that his testimony would benefit the trier of fact and would be a reliable benefit to the trier of fact in this case. The trial court specifically found that based on his education, his experience, and his qualifications, that he did not have sufficient support for his opinions. We respectfully disagree. I have the ultimate respect for the trial court, for Judge Stevens. And we understand the task that we have here today. That task is to show not only that an error was made, but that essentially that an abuse of discretion occurred, because it is an abuse of discretion standard. And we respectfully believe in this case that the discretion was abused, and we believe it was abused for these reasons. Dr. Orr's testimony, his opinions, his qualifications, his education, his experience came before the trial court on the basis, first of all, of an expert witness disclosure that was filed in this case by the plaintiffs. Secondly, a very short deposition that was taken in the state of Mississippi by the defendants approximately 9 months before they filed their motion to dismiss shortly before the trial date. Third, a declaration that Dr. Orr filed once the motion to dismiss had been proffered by the defendants. And fourth, an amended declaration that Dr. Orr filed as a result of responding to some of the things that were raised by the defendants in their motion to dismiss. So there are 4 operative pieces of evidence that were before the court. What do they establish? They establish that he was licensed. They establish that he was licensed in a contiguous state. They certainly established that he was practicing medicine in the year in which the alleged negligence occurred. So we then must focus, as did the trial court, on the second prong of that test in that statute, which is, did he demonstrate sufficient qualifications so that his testimony would be of aid and benefit to the trier of fact. And we examined.
I'm sorry for interrupting. Yes. Was he proffered as an expert in urology or emergency medicine?
He was proffered as an expert pertaining to the identification of, recognition of, and treatment of post-surgical conditions. Sepsis is what developed in this patient. And the septic condition developed between January the 14th and January the 18th. There is no criticism of the surgical procedure itself offered by the doctor. There is no criticism of the decision to do the surgery. What was criticized by Dr. Orr is a period of 4 days in which multiple complications occurred. And those complications were not recognized and acted on by the physician that had performed the surgery. And as you look at Dr. Orr's deposition, his disclosure, and the 2 declarations, he essentially says the following. He says, I was involved in the practice at that time of emergency medicine in Mississippi. Now, he had a 7-year residency with the University of Tennessee in Memphis, but we certainly understand that residency is not the basis for making him an expert. So it's his actual practice of medicine at that time. And since that time, he is a highly qualified and acclaimed expert in the type of procedure that was performed here, abdominal surgery. But we understand that that's not at issue here today. What is at issue here today is what were his qualifications at that time. And his testimony was that he provided emergency surgery, medical services in the state of Mississippi. He had done so for months prior to January of 2014. He testified in his deposition and particularly in his declarations, where he went into specific detail, because he wasn't asked much about it in his deposition. But in his declarations, he went into specific detail that as a treating physician in an emergency room setting, he on many occasions encountered patients that developed post-surgical complications, including the development of septic conditions.
So he was an emergency room doctor?
He was.
I thought you said something about emergency surgery.
No, if I did, I misspoke. He was
Okay.
an emergency room physician,
Okay.
not emergency surgery at that time in 2014. He said that he, on numerous occasions, encountered patients that developed post-surgical infectious disease processes, including septic conditions, that he was familiar with the complications that would evidence themselves in the way of symptoms for those patients, and that he was familiar with what you had to do in order to address those complications. Specifically, in this case, he pointed to the development of significant post-surgical pain, rapid heart rate, which in this case was unexplained by a consultation with a cardiologist, nausea and vomiting, sepsis alerts based on the hospital's own sepsis alert system, shortness of breath, abnormal oxygen saturation levels, abnormal lactic acid levels, weakness, and inability to thrive. The patient wasn't even able to walk after the surgery because of the severe pain, and elevated white blood cell count. And the doctor testified that he had encountered these types of complications in patients in an emergency room setting post-surgery, not surgery that he performed, but post-surgery, that he had recognized the development of these septic conditions and that he had then taken actions to address these problems, either by referral out or taking other actions to attempt to diagnose whether in fact there was a septic condition.
So he stated that he had encountered these situations in the emergency room.
He did, and you
Was
will
that
find
in his declaration? Or?
it's in his declarations. Yes, there's a declaration and an amended declaration. There's a bit of testimony about it in the deposition, and there's there is some reference also to that in his disclosure, but it's primarily in the declarations where he goes into significant detail that he was not asked to expound upon in his deposition. He then goes on in the disclosure and the two statements, declarations that he submitted to say what these signs and symptoms could lead to, and in fact did lead to in the case of Mr. Dallas Hurley. He testifies that when you recognize these symptoms, that you immediately must take preventative measures to determine if there is a septic condition or not and treat those measures. And he testified that that was not done on a timely basis in this case. In fact, the patient didn't get his surgery until the 18th, an exploratory surgery that in fact found that he did suffer from severe sepsis, that there were abdominal leaks that were resulting in significant contamination into his body cavity. So we believe respectfully, and I know if I can just take one more minute and then I'll reserve 4, is that okay?
Sure.
Okay. So in his testimony, he says that had preventative measures been taken upon the recognition of these multiple symptoms, that a different outcome would have been more likely than not for Dallas Hurley. And it is the recognition of these symptoms of sepsis that Dr. Orr basically refers to as basic medicine. These are the signs and symptoms that are looked for after any surgical procedure that could result in the development of an infectious process for the patient. And to the extent that that infectious process, Dr. Orr says, turns into a septic condition, then we have a life-threatening condition for the patient. It is that danger, it is that harm, and it was that negligence that Dr. Orr was critical of when he submitted his opinions in this case.
Okay, thank you.
Thank you.
Good morning, Your Honors. May it please the Court, Josh Bond for the Appellee from Hodges, Dowdy, and Carson. Respectfully, the trial court was correct and acted within its discretion. The trial court appropriately held that Dr. Wayne Shannon Orr was excluded from testifying pursuant to from offering testimony in this case pursuant to 2926-115B because Dr. Orr did not practice in a specialty or profession from January of 13 through January of 14 that would make his testimony relevant to the specific issues in this case. The code is very specific as to the requirements of the trial court's role as a gatekeeper and the duty that the trial court has in this case. And Mr. Hurley's correct, this is reviewed under an abuse of discretion standard.
Okay, Mr. Hurley says that Dr. Orr knew all about sepsis and the treatment of sepsis. What's wrong with that?
There's a big difference, Your Honor, in the treatment, or the diagnosis of sepsis in an emergency department setting where, and I'll point the court to the supplemental declaration of Dr. Orr signed on August 21, 2023, where Dr. Orr says, quote, on paragraph 9, during my time at South Sunflower Hospital between June of 11 and June of 13, it is my recollection that the hospital did not, it says did not radical cystoprostatectomy surgery, but they did do abdominal surgery. I remember surgical patients that came to the ER and had post-operative complications, which included, but were not necessarily limited to, infections. South Sunflower often did not have a surgeon on call, so patients that came in with surgical needs had to be transferred. Similarly, the hospital did not have interventional radiology. I would have to work on transferring those patients to different hospitals, usually Memphis or Jackson, Mississippi. Memphis, Tennessee, or Jackson, Mississippi. Dr. Orr was not a surgeon. He did not practice surgery in the year preceding. He practiced emergency department medicine. This is an entirely different setting from that of an attending urologist performing these highly complex procedures, such as Dr. Orr conceded in his deposition, in a teaching facility, and determining when you have this constellation of symptoms, whether or not this is expected postoperative pain, whether or not this tachycardia might be related to a different, to another medical cause, such as withdrawal from tobacco, such as the patient's underlying conditions, and the decision of when an exploratory surgery needs to be performed. That's the criticisms of Dr. Orr. And if you look at his deposition, and with respect to Mr. Hurley, I disagree with his statement that Dr. Orr ultimately conceded that there was criticisms of 4-day postoperative surgical care. Dr. Orr in his deposition testified that he was critical that Dr. Pickens didn't return the patient for surgery. I believe it said mid-morning of the 17th of January, instead of when it ultimately occurred, which was early the morning of the 18th. So the criticism is the failure of Dr. Pickens to open the patient up, not emergency department practice.
So you're saying, Mr. Bond, that the expert needed to be someone specifically familiar with the type of surgery he had and resulting complications. It was not enough to just have someone who was an expert in sepsis or had experience in diagnosing and treating sepsis.
I think it goes maybe a little bit further than that, that in order for the trial court agreed in the order that Dr. Orr did not perform surgeries, and for the trial court to criticize, or for the trial court's determination on this for the exclusion of Dr. Orr should be justified that Dr. Orr did not practice surgery. Dr. Orr was a surgical. He was a surgical resident, but he was not practicing surgery. He was practicing emergency department medicine as far as the qualifications of the statute. So to allow Dr. Orr to criticize the determination that at any given time that the patient either should or shouldn't be taken for an exploratory surgical procedure, it's not appropriate based upon the practice experience and the practice setting of Dr. Orr in the year preceding the events.
If someone is an expert on sepsis, wouldn't they be able to tell when surgery was indicated, even if they weren't a surgeon?
I don't think so, Your Honor. If you are, just because a person might become septic, it doesn't mean you perform an operation on them. That's an entirely different question. If somebody's becoming infected or having a systemic infection, most of the time it's treated with antibiotics. A patient's not opened up every time. That's entirely. Now we're dealing with a post-surgical patient in this particular setting, where there are medical judgments rendered every day about the constellation of symptoms that this patient may have. And Dr. Orr did not practice in that setting. He didn't have admitting privileges at any hospital, let alone South Sunflower. All he could do would render emergent care in the ED, and then if the patient even needed to be admitted at South Sunflower, he would have to have an attending admit the patient, or he would transfer the patient. It's entirely different than post-day surgical 3 or 4 setting following a radical cystoprostatectomy and removal of lymph nodes. And even as Dr. Orr testified and I've quoted it in my brief, that it was a very big procedure. It was a highly complex procedure. If you look at the cases, and I think it is, and I wanted to respond to one other thing. I would not criticize Dr. Orr's deposition as being a short deposition. It lasted several hours, and it established that Dr. Orr was not practicing surgery or practicing in an area that would make his testimony relevant for the accusations and in this particular case of substandard care. If you look at the complaint, and I have got I think it's page 3 or 4 of the technical record, the criticisms are related to failure to diagnose and treat this anastomotic leak, which is about perforation, which is treated by surgery. I think you look to the Shipley case, and that's extremely important, where the Supreme Court stated that trial courts, quote, must look carefully at the particular issues presented in a case to determine if an expert practices in a profession or specialty that would make the expert's testimony relevant to those issues. It's technical record page 3, where the plaintiff alleged that the plaintiff experienced bowel perforations that required surgical repairs. Dr. Orr, as we said, was not a surgeon. The only thing Dr. Orr could do at that point, if he suspected that if a patient came into South Sunflower while he was moonlighting in the ED and said they'd had some surgery, had recent surgery, the only thing Dr. Orr could do would be transfer the patient to a surgeon at a different facility, usually Jackson or Memphis. And then that surgeon would use his or her medical judgment to determine whether or not additional diagnostic testing is required, whether or not laboratory testing was required, whether or not the patient should be admitted, whether or not an exploratory surgery should be performed. That is way out of Dr. Orr's wheelhouse at that time of his career. Now, subsequently, Dr. Orr went to MD Anderson, spent 3 to 4 or 5 years, I don't remember how many, getting greater training and being fellowship trained.
Why wouldn't that go to the weight that the trier of fact would give to Dr. Orr's testimony rather than the testimony itself?
Because if the question is, what would the subsequent training of Dr. Orr, would that go to the weight?
No.
Oh.
Well, you said he would transfer, what he would do would be transfer it to a surgeon who would do other things to evaluate. And, lots of doctors transfer other patients to other doctors for treatment, but they might know about that treatment. And why wouldn't Dr. Orr know about that treatment? And why wouldn't that go perhaps to the weight you give Dr. Orr's testimony rather than prohibiting it totally? Because
the criticism is the lack of surgery, the lack of performing an exploratory surgical procedure. Dr. Orr didn't practice in surgery. I think if you look at what the cases, and that's what we need to look at, such as Shipley versus Williams, it did involve a general surgeon defendant where the plaintiff's expert was an ED physician, but the testimony regarding the standard of care that was permitted by the court and ultimately the Supreme Court was related to coordination of care between the emergency department physician and regarding follow-up. And the underlying facts are really important in that case. The defendant, general surgeon, told his patient to go to the ER. Then the defendant, general surgeon, spoke with the emergency department physician and not only spoke with the emergency physician to gather information, but also to recommend a specific course of treatment. Then they discussed what the follow-up care would be. And that's an entirely different situation where the court allows an emergency department physician to discuss what the standard of care is regarding coordination of care and continuity of care. If you look at the Mitchell versus Jackson Clinic case, which I've cited, involved a newborn with increased bilirubin levels that was discharged approximately 56 hours after delivery, with increasing laboratory testing demonstrating the increasing bilirubin levels. The plaintiff was an ED expert who testified that he often treated newborn patients in the emergency department setting and thought that and taught residents regarding jaundice in newborns. The Court of Appeals, this court, held that the trial court did not abuse its discretion disqualifying the emergency department expert, and where there was no evidence that the ED expert could offer standard of care testimony against defendant pediatricians, because in the year preceding the care, the ED expert was practicing emergency medicine and only quote, seeing jaundice infants in relation to their admissions in the ED, and not as a specialist like the defendant pediatricians. The Court of Appeals further said that, acknowledged that you don't have to be in the same specialty to be an expert, but the pro-offered expert must have practiced in an area that would have made the testimony relevant to the issues of that particular case. And based on the Mitchell versus Jackson Clinic decision, it's clear that while an emergency department physician may treat patients in an emergency department setting addressing many ailments, I mean, they get a constellation of symptoms. It doesn't make them, an emergency department physician, an expert in every case. And just because they may treat patients and refer them to specialists. The practice setting is not often similar to attending specialists for purposes of TCA 2926-115B. And in Mitchell, the case that upheld the trial court's discretion of excluding the expert, it did not even involve such a highly specialized area such as this particular case regarding surgical procedures that are extremely complex, even as conceded by Dr. Orr. Briefly, I've got about a minute. The cases cited by the plaintiff, they're not similar to this matter. I've outlined the facts in them involving my personal general practitioner growing up from Lebanon. Dr. Bryant is one of them, performing an appendectomy. The court ultimately permitted a infectious disease expert from Vanderbilt who practiced also general medicine to offer criticisms, but the allegations in that case involved or whether or not Dr. Bryant should have ordered empiric antibiotics before the surgical procedure, and whether or not he ordered appropriate antibiotics after the procedure. I'm running out of time. The other cases cited by the plaintiff are not similar to our situation. I think we look at the discretion of the trial court, and the discretion means discretion, and it was not an abuse of discretion by the trial court in this particular matter.
Thank you.
Thank you, Your Honor.
Mr. Hurley, per our agreement, you have 4 minutes, and I would like to hear what you think about the Mitchell case upon which Mr. Bond relied so heavily.
I think the Mitchell case upon which the defendants rely so heavily, it says what it says, certainly, but it must be read in context of the two other cases that we think are absolutely relevant and we would assert controlling in this situation, and that is the Shipley versus Williams case, in which the court specifically recognized that an expert witness must not be of the same specialty in order to testify as an expert witness in a medical malpractice case. And the Searle case, which is, and of course, Shipley, a decision by the Tennessee Supreme Court, and then the Searle case, a 1986 decision by the Tennessee Supreme Court, in which a clinical microbiologist and infectious disease physician was allowed and recognized as an expert witness by our Tennessee Supreme Court in testifying against a surgeon that was a defendant in a case that involved surgical procedures. So, yes, that case says what the defendant says that it said. However, it must be read in the context of these two Tennessee Supreme Court cases that say point blank that you do not have to be of the same specialty in order to offer relevant evidence as an expert witness in such a case. And I would close with this so that I will actually finish inside my 4 minutes, I hope, here. What happened here was, as the court, we respectfully believe, as the court looked at the arguments made by the defendant, the court, we believe, was persuaded as to the weight that should be given as opposed to the admissibility of the testimony. The discretion of the court is not abused unless the court misapplies the minimal requirements of the statute that we have cited in this case. And if Dr. Orr provides testimony that is relevant and establishes that he meets the minimum standard qualifications under that statute, then the court is to admit his testimony, and the question then becomes the weight of his evidence, the weight of his testimony, to be determined by the trier of fact in the case. Now, had Dr. Orr not offered any testimony whatsoever about having had experience with septic patients, had Dr. Orr offered no testimony or evidence that he had ever treated a patient that had post-surgical septic conditions, had Dr. Orr testified that he really wasn't familiar with the complications and the signs and symptoms of the development of sepsis, absolutely in those situations, I believe we would have had a severe problem. Because in those situations, the trial court, in the exercise of its discretion, could have rightly found that the testimony that he offered did not provide relevant and helpful evidence for the trier of fact. In this case, we respectfully believe that he testified that all of those things did exist. He had that experience, he had that training, he had that education, and we believe respectfully that the court abused its discretion as a result.
Thank you. Thank you both. Would you please call the next case?